People versus Wayne Tahada.
Good afternoon, Your Honors. Appellate request 5 and 2.
5, 2, and 5. Thank you. Quiliqui versus Gladen Properties. Sorry if I've mispronounced that.
Appellate request 5 and 2. Respondent request
5, 2, and 5. Thank you. Marblet versus Xavier. Submitted. Castillo versus Shay.
Just hold for appellant 3 and 1, please.
3, 1, and 4. Thank you. Bartley versus 76 11th Avenue. So we have a submission on the other side. Do you want to argue or submit? Submit. Thank you. Goodwin Law versus Wang. Okay. I understand that you're a respondent?
Yes.
I understand that the appellant is running late. Let me call that at the end of the calendar, okay? See if they're here by then. Clark versus Con Edison.
Request 6 and 2, Your Honor.
Respondent request 5, Your Honor.
4 and 1 and 5. Global IX versus Hogwarts. I'll give you 6 and 2. 6, 2, and 6. Thank you. People versus Joel. Joyce.
Appellant request 7 and 2.
6 and 1 and 5. Stevenson versus New York City Transit. 5 and 1 and 4. Thank you. Falcon versus New York State Psychiatric. There appears to be no one here. You're the respondent, aren't you? I beg your pardon? Do you want to argue against yourself here for 4 minutes?
No, thank you.
Okay. Thank you. People versus Richard Vester. Submitted. Rothman versus Radna. Yes, I understand that the other party is running late, so I'll give 5 and 2 and 5, but we'll clear it when they get back, when they arrive. And then on Goodwin Law versus Wang?
Yes.
Yes. You are the respondent?
I'm the respondent.
And you asked for?
We asked for 15 minutes. If she shows up, maybe the court could just do 5-2 for the appellant and 5 for the respondent.
Okay. You said you are the respondent, is that right?
Yes.
Okay.
5. I'm assuming
You're asking for 5 minutes. That's what I heard.
if she, yes.
Okay, so I'll put it 5, 2, and 5 for now, and we'll see what happens. I may call the case at the end of the calendar, okay? First case for argument is People versus Wayne Tahada. Counsel?
Good afternoon, Your Honors. My name is Brian First from the Center for Appellate Litigation, and I represent Wayne Tahada. I understand that I am asking a lot of the court here, but I believe that if you look at the details of Wayne's life, you will see that this is the rare case in which YO is warranted despite what are admittedly horrible factual allegations involving the sexual abuse of children.
it's beyond sexual abuse. He raped his young nieces between the ages of 9 and 11.
Yes, Your Honor, and I'm not here in any way to defend what Wayne did or create excuses or justifications or say that there shouldn't be consequences for that. There should be consequences, and my argument here is that given Wayne's intensely traumatic life and all that he has experienced and his incredible...
Counsel, even if we feel that he has had a horrific life himself, that he's now perpetrated upon these 3 young girls, 6, 7, and 9, what about him now will give us confidence that when he's released in 3 years that you're asking for from the time from about now, or whatever it is, he is still going to be a young, healthy, strong man, capable of raping a woman, a child? What gives us confidence that he won't do that?
Yes, Your Honor. So first there's every indication that he is an incredibly low risk to reoffend. And first, if we look at the big picture data on adolescent sexual offenders, we have a DOJ meta-analysis, which shows it's not just a one-off study, it's evaluating every study that's been done on this topic, finding that the overwhelming majority of adolescent sexual offenders never sexually reoffend. We're talking 87
But what are we
to
talking
93%.
about when we talk about this study? Sexual offense, that's a big thing, from touching to brushing to fondling. We're talking rape in every way of 3 young girls. Not 1, 3. Repeatedly.
Yes, Your
And
Honor.
so I don't know what your study is comprised of in terms of what the acts are. But unless you can tell me that they involve other people who have raped multiple victims in multiple ways, how does that give me confidence?
Well, the studies do encompass all, you're right, Your Honor, it encompasses more low-level sexual assault, but all the way up into the most serious sexual assaults. And my point to cite this research is just as a baseline. It is not my primary argument. It's just the baseline to work off of. But we have individualized evaluations of Wayne. We have both an independent expert on adolescent sexual offending and docs have both determined that Wayne is a low risk to reoffend. And if we look at, it was Dr. Keith Cruz, he's a Fordham professor of psychology and an expert on adolescent sexual offending. He evaluated Wayne ahead of his 2019 sentencing and the 2022 resentencing. And
didn't that report also indicate that he denied any contact?
he did in those interviews with Dr. Cruz, he did deny that there was contact, but I want to emphasize that Dr. Cruz assumed for purposes of those reports that he did in fact commit everything that was alleged. I would also say that the traditional concern with denial of responsibility is that a defendant isn't going to take, if they don't think they've done anything wrong, they're not going to engage wholeheartedly in their rehabilitation. And as far as this case goes, nothing could be further from the truth. Wayne has wholeheartedly embraced his rehabilitation. He's sex offender therapy included and agreed to continue sex offender therapy in the community when he is out. So, but just returning to...
Also, didn't Dr. Cruz originally find him a moderate risk, and then subsequent to him completing the program, he became a low risk? And didn't the court consider all of that in deciding not to give YO?
So there's 2 parts to your question, Your Honor. And so yes, he did originally find that he was moderate risk, and I think this is critical here. When he did so, he specifically said that he was not finding that because he believed that Wayne had any attraction to young children, of which he found no evidence of. What he said was that children who commit sex offenses often do so for reasons that have nothing to do with attraction to children, but do so because of all manner of reasons, which include abuse, negative antisocial attitudes, peer pressure, bad environments. And for the case of Wayne, it was because of this trauma that he had experienced. And so what he found was that he didn't know how Wayne was going to respond, it was a long time ago, how he was going to address this trauma. But when he interviewed him 3 years later and saw the tremendous growth that he had gone through, all of his concerns were allayed and he reduced his risk accordingly.
Thank you.
And the court considered that, correct?
The court did consider that to a certain. I don't believe that the court never recognized that. The court framed the question here. He framed the question as is his good work, quote, his good work versus what these girls experienced. And if that's the question here, that's an impossible hurdle to overcome. But there's so much more to the calculus in a YO analysis than simply his institutional record, and we can discuss that more.
Thank you very much.
Good afternoon, Your Honors. May it please the court. Jennifer Cavallas for the people. The resentencing court, like 2 other courts before it, correctly found that the interests of justice were best served by denying defendant youthful offender treatment. And additionally, defendant's negotiated sentence was fair in light of the lengthy consecutive sentences he faced. The purpose of youthful offender treatment is to avoid stigmatizing youths for hasty or thoughtless crimes. Far from being hasty or stemming from a momentary lapse in judgment, defendant's actions were premeditated and deliberate.
So what about the study that counsel just said that the psychiatrist or psychologist has done that shows that this was not just a sexual attraction or was not necessarily due to a sexual attraction, but due to abuse? What about those factors, and should they weigh on our decision here in terms of the fact that the doctor saw that he had first moderate and then changed his view about his behavior given the treatment? And don't we want people to go to treatment and to be encouraged to continue with treatment?
2 things, Your Honor. First, defendant received treatment in Rikers, and then when he was transferred to upstate, he didn't find those services beneficial to him. He didn't like those services, so he stopped attending those services that he claims were necessary to his recovery. So the fact that defendant has stopped that treatment speaks to his poor prospects for rehabilitation. That's number 1. And 2, the interviews with Dr. Cruz, all the things about defendant's predilection towards children and Dr. Cruz's opinion that he did not have that predilection were based solely on defendant's own opinions. These opinions were nothing based other than defendant saying, I don't have a sexual predilection towards children, I will not reoffend. There was nothing in those reports more to substantiate that.
Doesn't it make more sense to analyze a YO status at the time of sentencing rather than do this look back that's being sought here?
Absolutely.
Fair enough. So in that context, Judge Roberts, who was asked to consider it and consider mitigating factors, that he's 16 years old and immature, his brain's not fully formed, all the other types of arguments that they're wont to make, which is fair, found that he actually claimed that he was forced to fabricate the inculpatory statements, that he'd been manipulated into making these false allegations, that someone else sexually abused him. That was going on before the sentencing court, correct?
Yes,
Did that sound like mitigating factors to give him a YO status?
no, absolutely not, because after defendant was arrested, he admitted to some contact with the children, but then placed blame on those children, saying that they initiated the contact with him, placing blame on 5, 7, 8, 11-year-olds. And then later, when he gets interviewed with Dr. Cruz, he denies the conduct altogether. Defendant submits letters talking about how he's dealt with his own trauma, but never once throughout any of the litigation here has defendant taken any responsibility for his actions. He's outright denied what he's done and placed those blame on his family members, on the children, on everyone around him except himself. So the fact that defendant has refused to come to terms with the gravity of the trauma that he's inflicted on these victims and instead relied solely on his own trauma to justify what he done is reason enough not to extend youthful offender treatment. And moving on briefly to the excessive sentence point, this was a bargain for sentence where defendant received a very lenient sentence of 9 years plus 10 for 2 different victims when those consecutive sentences could have ran up to 50 years in prison. So this was clearly a very fair deal, and there's absolutely no reason for your honors to extend YO treatment or reduce defendant's sentence. If there's no further questions, we ask that you affirm. Thank you.
Just briefly before I address the excessive sentence point, I want to point out that Wayne did not stop all programming when he went upstate because he didn't find it beneficial. The only thing that he stopped attending were mental health services because he signed up for them and then he was seen by a provider twice in 9 months. Clearly, it was not effective mental health treatment, so he was not going to go through that charade. But he did all other programming, including sex offender therapy programming. But moving on to the excessive sentence points, when this agreement was made, nobody could have predicted that there would be a SARA housing restriction-fueled crisis in which people were being held past their conditional release dates, past their maximum release dates, because there were no beds for the people to go to when they get out. So when he was sentenced to 9 years with good conduct, he's supposed to get out in February of 2025. But because if he was a wealthy person and could live in the 3% of New York that is SARA compliant, he would be getting out that date. But because he's poor and his only option will be to live in a SARA compliant homeless shelter on Ward's Island, that he will have to wait for a bed to open. And his name will go on that wait list until he reaches his maximum release date. So despite good conduct, where he was immaculate conduct, he will be forced to stay in prison. It could be up to 2 years longer than he should be. So that alone is reason to reduce his sentence by 2 years, which would allow him to get out at a similar time that the court envisioned when he got his original sentence.
So we're speculating as to that. We don't know that that would happen because we're not in 2025 yet, right? So it is entirely possible that something happens and that there's a bed available for him. Am I correct?
Your Honor, I hope that there's a miracle and the city all of a sudden builds a new shelter and there's more beds, but that would have to be in the works by now, and there's nothing in the record
Or that
to that
there's some
effect.
other reason why a bed is available.
But it is in the record that none of his family lives in that 3% of the city which is available. And the last point to the PRS, because he has SARA housing restrictions, he will have to be in that homeless shelter for 10 years, the entire duration of the PRS. So we're just asking if you reduce that PRS, that will ameliorate one of the most punitive and harsh aspects of sex offender registration. And I'll just lastly point out that because children are so different from adults when it comes to sex offenses, the DOJ recommends that children not be labeled as sex offenders for life and they not be treated the same way adult sex offenders are. Thank you, Your Honors.
Thank you both. Kiki versus Gladen Properties.
Good afternoon, Your Honors. Alan Russo and Gould for the appellant, Gladen Properties. This case is a relatively straightforward.
And we've all seen the video.
Yes.
And we all have seen that there are no mats. Mats weren't kept. The photographs are of new mats, or in any case, not the mat. And you have an expert who didn't take pictures or visit the place until almost 4 years after the incident. So why was the judge wrong here in finding that?
Okay, well, first of all, the
against you
video
here.
itself, which shows the accident itself, does not show a defective or dangerous mat. What it shows is somebody.
Impossible to determine anything from it.
What's that?
It's impossible to determine anything about the mat from the video.
There was well, you could see in the video that she steps, she has no problems, and then she drags her heel as she's coming
I
up.
see that she drags her heel, but I don't know if the mat is lifted a bit, and if that's the reason she falls, or if it's because she drags her heel and pulls up the mat and gets caught.
The claim in this case.
Or
is
at
that-
least what I think has nothing to do with what 11 other people might think on a jury.
There was
But
evidence.
that is possible.
In addition to the video, there was a photograph taken that day by someone who worked at the building that was attached to the accident report, which shows the mat flat and in a perfect condition. In addition to that evidence, there's evidence from the fire warden at the building, the property manager at the building, the two co-employees from Pritchard who testified that there was nothing wrong with any of the mats, including this mat. And no mats had been changed or repaired from the day of the accident until the date the expert came. That's the evidence.
Wouldn't the best evidence have been the mat?
The mat itself?
That's the one we're talking about.
That's right. Well, the expert reviewed all of the mats and didn't see
No,
any.
the mat in question, not any other mat.
There was a photograph taken of the
No,
mat
I'm
in
talking about the
question on
actual,
date in
counsel,
question.
please, don't speak over me. I'm asking you about the mat that was in the elevator at the time she fell.
Yes?
I'm asking you, was that mat kept? Where is
Yes.
that mat?
It's still at the building, as of the date the expert examined them. There's testimony in the record of 4 or 5 witnesses that none of the mats were damaged, none of the mats were repaired, and that the mats that the expert looked at 4 years later were the same mats that were in the building at the time of the
Including
accident.
the actual mat.
Yeah, including the actual mat that was involved in this case. And there was a photograph taken that day after the accident that showed the mat.
Yes, except, counsel, what you're saying is these mats are rotated all over the place. And after this event happened, the mat was not taken, removed, and kept to be examined. Is that correct?
That is correct. There's no reason to take it and to be examined, hold it to be examined. There was nothing wrong with it. That's what the proof is in the case.
One party's belief.
Okay, and then the second part of my argument is that I represent Gladen Properties. We're the owner of the building. There was never any proof submitted of any notice to us of any problem with the mats.
But the issue here, and there was some inconsistency because your contention is that Pritchard is an independent contractor and they stand alone.
Yes.
That's a fair point. But then on 390 of the record, of Ms. Arlington's affidavit, and I'll read from paragraph 7, Pritchard is responsible for identifying it, the mat repairs, and notifying building management of the need for replacement. So that built into your relationship was the fact that they had a duty to inform you of what was going on. So that's pretty much inconsistent with taking the position that they stand alone. Would you agree?
Well, when you say they stand alone, in order for the building to be responsible for any notice given to Pritchard, it has to go beyond just a contract. It has to be a real agency relationship.
Yeah, but
They
Why
can't
isn't
be.
this an agency?
It's not an agency relationship. It's a cleaning contract. And the fact of the matter is, the 2 co-employees of the plaintiff testified that they never told the building there was anything wrong with the mats.
But she did.
She told
Pritchard.
there's a dispute.
Several months ago.
Yeah, one of the co-employees, there's a dispute in that testimony. But the fact is, we represent Gladen. And if that employee says, she never told me that, then that's consistent with the building never being told there was any kind of problem with the mat.
Thank you.
Good afternoon, Your Honors. Cornelius Redmond for the respondent, and I think just from...
Do the pictures submitted show the mat
I don't
as it
bel-
was?
That's an argument that we have, Judge, because there's a problem with the chain of custody. They took a very small snippet of a video from when she fell. Now, listen, if they had continued that video and showed somebody taking a picture of that exact mat right after that, and we could see that, they didn't show that. They cut off the video after 30 seconds. You see, they're claiming that the mat that they took a picture of at that time was the same mat. It would have been very easy if they just kept that video, which was entirely in their control, and showed someone taking a picture of the mat at the time. And we could have looked at the metadata that showed the exact date and time of that photo. They didn't do that. They destroyed it. So there's a chain of custody issue, and that lends itself to a decision that has to be made by a jury. We don't know that she dragged her foot. You don't have a video that shows the view of her foot of underneath that, whether she lifted it up or not, and you cannot see from that video if there is a curled up mat in that situation.
What about notice?
Well, Your Honor, the porter themselves put out this mat, and if in fact had that condition on it, they would have seen it, should have seen it, they should have looked at it, and by their own admission, they're supposed to inspect these mats. They're supposed to see if there's a condition like that. That's number one. That would be constructive notice. And then my client is saying that she told her supervisor that the condition was like that. I know there's a dispute as to that, but...
Does Pritchard's argument that they had no notice and they're not agents conflict with Arlington's testimony that Pritchard was responsible for notifying the defendant when the mats were required to be changed?
It does
repaired?
conflict, Your Honor, absolutely. But it's our position that the notice to Pritchard conveys agency to Gladen, because Pritchard is her overall supervisor. They're supposed to tell Gladen. If they didn't do it, that's...
They indicated that was part of their responsibility.
Yes. But the problem is that, now they're saying they didn't even get the notice.
So can we go with the video alone? Seems that she has her heel up inches before the mat, and she drags her heel back as she's moving and catches the mat, and she falls. Do we really need the mat?
I think there's a question as to whether she did lift the mat with her heel, if she did drag it. Like I said before, you cannot see by the video if there's any space between her heel and the floor. I mean, that's an assumption about the way she did move her foot. But in terms of, they're saying that she didn't even look at the condition, but you can see her in the video looking down right at that mat. So, and she did testify that it had a curled up condition.
Thank you.
Thank you, Judge.
This is a very busy office building in Manhattan. God knows how many people went in and out of that elevator every day, all day. If something happened immediately before this accident, even assuming, which I don't concede this at all, there's anything wrong with the map as I see it in the video and the photograph that was taken. If somebody did something to the mat to lift the edge of the mat, you can't hold the building owner responsible for that. There's no proof how long that existed, if at all, and I don't accept it even existed. And in fact, the photograph that was taken the day of the accident is part of the accident report, which is in the record. They want to speculate that it's some sort of fabrication. The accident report describes the accident the way the plaintiff described it to them. So there's, they're not trying to, the building's not trying to hide anything. Their description is what she told them. They wrote it down, then they went and took a photograph. And that was part of the accident report.
There's a question.
Counsel, how do you reconcile that position with plaintiff's testimony that the mat was defective and that there was that she notified them and it was an accident waiting to happen?
How do I reconcile it? She continued to work in that building for 4 months after the fact. If you assume that what she's telling is the truth, even though it's categorically denied, she continued to work. She knew about the condition. She was looking at it before she walked into the elevator. If she knew it was there, that sort of kind of contradicts her testimony. Her testimony is purely speculative. It's based upon what if this, what if that, what if this. There's no evidence that
It's based on a mat, not a what if. It's based on a mat. She said the mat was in disrepair. We don't have the mat. You say you have the mat, but there's no way we figure out what the mat, which mat it is. Thank you very much. Thank you both. Castillo versus Shay.
Good afternoon, Your Honors. May it please the court. My name is John Scola. I'm here on behalf of petitioner appellant Robert Castillo. Now, there's a lot of procedural arguments here, and I'm going to the most important one is the rules of the city of New York state that when an officer is served with charges, he must be given notice that he can reply in writing within 8 days of the charges if they're given personally, or 13 days if he's served by mail. The NYPD, as a matter of course, does not give their officers proper notice of their ability to respond in writing. So it's petitioner appellant's position that this automatically requires reversal because they didn't obtain jurisdiction over my client. Now, the city, the NYPD rather, uses 3 main laws to govern their disciplinary procedures. It is the Administrative Code, it's rules of the City of New York, and it's Civil Service Law 75. The courts have said repeatedly that Civil Service Law 75 does not apply to NYPD disciplinary proceedings. Yet, the NYPD uses it to govern these proceedings and really impede on their employees' rights. They use Civil Service 75 to govern suspensions, the statute of limitations, appeals, cross-examination, defenses, witnesses, the mitigation of damages, suspension, termination, and fines. This body of law, time and time and again, does not apply to police officer disciplinary proceedings, but they insist on using it. Their failure to obtain jurisdiction over my client renders the decision reversible. It should be reversed automatically, and he should be reinstated as a police officer. Now, if you get to, now there's other due process issues here with the sealing of records. So I have a weird niche where I sue the NYPD for a living in an employment context. So I have a lot of these cases where they're arrested. When you're arrested, you beat the case. So the case is dismissed. The NYPD are the ones that committed they arrested the employee. It's dismissed in criminal court. They then use the records that they obtained during the arrest in an internal disciplinary proceeding in order to discipline the officer. In this case, it seems that the respondents' arguments are they had the records, but they didn't actually admit them into evidence, even though the reference on the record by the judge about the domestic incident report, they used these records to discipline the officers. Now, there's a case, Charles Q.
So they're saying they didn't unseal the records.
Absolutely.
But you're saying they didn't unseal them because they had them from the very beginning and they used them.
That's correct, Your Honor. So the law is clear, though. So once the records are sealed, they have to, they're supposed to destroy them. And then if they're going to use them in disciplinary proceeding, they have to make an application to a court and be given permission. They didn't do that here. They don't do that as a matter of course. That's the reason why Charles Q is not applicable.
Thank you.
Tahara Sadria, appearing on behalf of the City of New York. The Commissioner's decision here should be confirmed. The petitioner was found guilty of 5 specifications in multiple incidents over the course of 2 years, and those findings were based on credible testimony.
Also, didn't he admit to some of them?
He did. He admitted to make multiple violations of the order of protection during the month of March. He admitted to failing to identify himself to an officer at the scene of yet another domestic incident that occurred 2 years after the first incident, and he admitted that he left his home without permission while he was on sick report, without permission while on sick report.
And the multiple violations in the month of March included going to his ex-wife's home, spending the night, which she didn't complain about, but his girlfriend complained about, and going to church with her on a Sunday. Those were 3 of the incidents.
Some of the, yes, in some of these incidents, the violations of the order of protection included him, yes, included.
I understand they violated the order of protection. I'm just pointing out what they were. He went to church on one day with her. That was a violation.
He did go to church, and yes.
He spent the night with her.
Yes.
That was a violation.
Yes.
There was no abuse that night.
There was no abuse, no, although
I understand it was a violation. He wasn't supposed to be there, but there was no issue.
I beg your pardon? I'm sorry.
I understand it was a violation. He wasn't supposed to be there, but there was no issue raised other than by a third party, right? The girlfriend showed up at the apartment the next day.
I mean, the wife did go and eventually complain about the incidents of the violations of the order of protection that occurred in March. I mean,
Anyway, we digress.
Okay.
Why don't you get back? I was just trying to clarify the kinds of violations those were. But why don't you get back to your point?
I would like to also point out that in the February violation that of the
I wasn't asking about that. There are 2 others, but you rely on 5 altogether. You didn't ignore the 3. You relied on 5. That's why I wanted to clarify what they were.
Yes.
So why don't you tell us about the jurisdictional issue that counsel raises?
Yes. There is no cognizable argument here that petitioner has suffered any procedural or due process deprivation. Petitioner consented to the admission of all of the exhibits that were before the administrative tribunal. He I mean, the only documents that he complained, the documents that he complained about, the domestic incident report in pre-trial conference was, there was an objection, and the department advocate agreed not to introduce it into evidence. While the hearing officer referred to the wife's testimony that she had filled out the domestic incident report and had given the officers an account of the incident that was similar to what she testified to, that was what he was relying on, was her testimony rather than the contents of the report itself, even assuming that it would properly be a sealed record, which, I mean, that's not really, doesn't need to be an issue at this point because it was not admitted in evidence. And with respect to the statement of the
Counsel, you mentioned that the sealed records that he's complaining about were not admitted to evidence, so they're not relevant?
to the extent that he's, no, they're not relevant.
To the extent what, I'm sorry?
I'm sorry.
I just didn't hear you, if you could
Okay,
just-
I'm sorry. He's complaining about reliance on sealed records, and none of the records that he didn't object to the introduction of anything that was actually admitted into evidence. The domestic incident report, which he's alleging was a sealed record,
I was really only asking you, I just missed that one word, and I was just really asking you about that one word.
Okay.
Anyway, why don't
I
you?
apologize.
Okay.
I apologize. There was no reliance.
In other words, he's saying that you relied on the sealed records anyway. You didn't need to unseal them. Once records are sealed, you're not supposed to be relying on them. But he's saying because you had them, or the commissioner, they were relied upon.
We relied on the testimony. I mean, in this hearing, we relied on the testimony of his wife. And under Charles Q, it is acceptable to, even in a case where ultimately there was a criminal case brought and the criminal case was ultimately dismissed, it is acceptable to rely on the complainant's testimony.
You're saying that you didn't.
I'm saying that we didn't rely.
You neither unsealed the records nor relied on those sealed records because you had the actual individual testimony.
We had the actual individual testimony, so there was no need to rely on sealed.
Counsel?
Yes.
Can you just address the initial jurisdiction, the initial counsel's argument that the initial service was improper? Can you just address that? I just didn't hear if you did.
Okay.
I don't think
there
you
is
did.
no petitioner's contention now that there was no jurisdiction because he was not properly served with notice is a contention that he has made for the first time on reply in this court. There, at the administrative proceeding and in his petition, there is no contention that he was prosecuted under the incorrect statute or that he was deprived of due process or that he was deprived of an opportunity to submit written response to which he was entitled. So that whole contention is not before the court. And it is in any event not correct. He was prosecuted under the administrative code, as is reflected in the commissioner's determination and in the notice of hearing. And all that he is talking about is references to the civil service law, and not, while the commissioner's jurisdiction to discipline officers is under the administrative code, there are aspects of the civil service law that are applicable. The Civil Service Law 75-3A specifically references police officers and says that, you know, the 30-day suspension without pay is, that is pursuant, that applies to the New York City police officers, and that was recognized by the Court of Appeals.
Thank you.
Okay, thank you.
Counsel, can you confirm as to whether or not the wife is still the wife, or is she the former wife? Do you know?
No, I'm not sure, Your Honor. I don't know the answer to that. I will agree that it's pretty messy, the whole situation.
Oh, I know they're estranged. I get that. I read.
No,
that.
I don't
Okay,
know.
thank you.
On this record,
Sure.
based on what your friend said to my colleague, did you make the equivalent of a 3211 motion to dismiss this for lack of jurisdiction, or the administrative version of it at the early stages?
So
For the hearing, did you raise this before the hearing officer? Did you, when I say you, whoever was
Yeah, I
representing him then, was an effort made in a post-trial or hearing memorandum to raise the jurisdictional issues? Or is counsel right? You raised this issue for the first time in reply here.
It's not raised for the first time on reply, no. We said that they didn't have jurisdiction over 70, from Civil Service 75 in our original brief. He can't object to not having jurisdiction over something he doesn't know about. It says here in the disciplinary matrix, it's on the record at A461, at footnote 15. It says that 7576 of the Civil Service Law mandate certain rights in the disciplinary action. Included in there are the opportunity to answer the charges at a hearing or otherwise. The otherwise is in writing with the original notice. That's governed by 38 RCNY 15(3)(b)(1). It says you have to give notice. They can respond in writing within 8 days or 13 days. My client was served with charges on January 27, 2017, August 29, 2017, August 14, 2019, November 18, 2019, December 15th of 2020. The record is absent of that notice because they don't do it. I have many clients, they don't give it. They pick and choose what to follow and what to use. This is a substantial.
I'm sorry, I didn't mean to cut you off. So that's my point. If you weren't properly served, isn't a motion supposed to be made or an application to dismiss it right out of the box? To come now after a full hearing, after being afforded due process and an opportunity to be heard, being able to testify at the hearing, to negate all the charges regarding the violations of the sick leave issue, the claims of violating the order of protection by the wife, all 5 charges as I saw on the record. There's no opportunity to do that. From my point of view, you waived it.
So I guess our response to that would be, this is a appeal to govern whether the lower court's decision was properly held. It's not reviewing it's not like he has to preserve that right. They never had jurisdiction over my client then, now, any other time. It's okay to be raised here because his lawyer might not have known that that was the proper procedure because it's not what they use. How would he know what to object to if they don't use it in their proceedings or in their mode of disciplinary proceedings? That would be my response to that.
Thank you. Thank you
all.
both.
Have a happy holidays there.
Thank you. You too. Goodwin Law versus Wang. Good afternoon. I just want to confirm that the
Apologize for
time.
my lateness.
Yes, thank you.
I was stuck on
is
Park Avenue in a cab.
a bad day.
Bad day.
5, 2, and 5. That's the time that was,
Fine.
is that fine? Okay.
Thank you. All right, as you know, Your Honors, this is an appeal from an order confirming a report from an arbitrator's award. And we're seeking to either vacate the award or remand it for a modification. We feel that a modification is the proper result here because of the arbitrator's refusal to consider the criminal conviction of Mr. Brody and her manifest disregard of the law. Kevin Brody's criminal conviction in 2019 of grand larceny and conspiracy, together with his co-defendant, Mr. Eckstein, does not exactly mirror the misconduct in the arbitration. However, I think it is substantially related. There's no need to mirror it. there's clear and meaningful connection. The monies that were stolen from the victims of the Ponzi scheme were deposited into CONMAC. CONMAC owned Beacon Partners. The monies that were removed from the DuPont account were, Chase account, were deposited into Beacon.
May
So
I
there's
just-
certainly a connection.
Can I just ask about Brody?
Yeah.
Let me just see. About Brody, because it seems that you rely on Brody, and it's that inconsistency you're talking about. But the standard, obviously, as you know, is so low for assessing these arbitration agreements, and this was a non-reasoned one, and the award only requires a barely colorable justification for the outcome that was reached. So I just want to ask you if you would clarify the aspect in the brief that speaks to Brody's testimony, that whether it was rational for the arbitrator to conclude that he wasn't involved in the Wahlberg project because he says he didn't sign the operating agreement, he didn't sign the First Amendment, he didn't sign the subscription, he didn't sign the letter, and he says that it was, I think his signatures were not his, they were not his signatures, and that I guess the arbitrator compared the signatures and found that they were suspect. And Pritchard said that he didn't know Brody until the arbitrator proceedings began, and Pritchard would have been. So how do we look at that and the arbitrator's assessment of that and whether that was reasonable or unreasonable?
Well, she obviously made a credibility determination based on his testimony, but there's also other testimony. There was testimony from Mr. Singer. Mr. Singer said that he was in touch with Mr. Eckstein. He knows that they worked in the same office, they worked together, they were involved with promoting these hamburger projects, et cetera, around the country, in Long Island, in Miami, in DC, et cetera. He said that there was a stamp with Brody's signature. It's possible that Brody did not sign it. It's possible that somebody else used his stamp, fixed an electronic signature, or used a stamp but we don't know that, and the record doesn't show that. The record doesn't prove that. And to totally exonerate Brody from any liability, where you have bank records showing that Mr. Brody, under his signature, was the one who transferred these monies out of the DuPont account into Beacon, I think is certainly more credible than Mr. Brody's self-serving testimony. I mean, he even minimizes the fact that he was convicted of a Ponzi scheme. He says, yes, he was convicted, but it wasn't really a Ponzi scheme. It was just failed investments. It was $12 million of failed investments with many victims that he and his co-defendant Eckstein stole from these people. Yes.
May I ask, the arbitrator was in fact aware of the fact that Brody had been convicted of had criminal convictions. I mean, she was aware of that. She did hear testimony or allow that to come in.
Yes.
So you thought she should have weighted in a different way that testimony.
But it just seems that this is an irrational award, that it really defies common sense not to attribute any liability to Mr. Brody at all, to completely exculpate him when his signature is all over the place. He was obviously involved with Mr. Eckstein in these projects, and he claims he was in Pennsylvania the entire time. That's where he lived. That he didn't live. He wasn't didn't go to D.C. He makes these claims, but I think that certainly we have other evidence. The bank records, I think, refute that. I mean, we have to assume and give a presumption of regularity to the bank records. there's nobody's really said that they're not valid. No one really said that it wasn't his signature except him. He recognized that it's being possibly his signature, and he told us about a stamp or an electronic signature that was in his office that somebody, Ms. Smith or somebody could have used. Oh, I see my red light's on, I'm sorry. I'll come back to
Okay,
rebuttal. Thank you.
thank you.
Good afternoon, Your Honors. May it please the court. Kerry Colton-Back on behalf of the respondents. The decision and order of Judge Bluth confirming the arbitration award of arbitrator Love should respectfully be affirmed. We have a standard non-reasoned arbitration award, and appellants cannot even come close to the very high standard of showing the award manifestly disregarded the facts and law or was wholly irrational, or that arbitrator Love engaged in misconduct. If I
Was
could...
it irrational to find that Brody, whose signature was all over these documents, was not involved with the transaction at all? What was the evidence that the signature, I mean, having an electronic signature is not unusual.
Right.
So it doesn't necessarily look exactly like one signature, but it's their electronic signature, and having that on a document, and later saying that it's not yours. I mean, what do we do with that? With the
Actually-
arbitrator's
Yeah,
assessment?
Actually, Your Honor, it's the signatures that make it look like Kevin Brody had little or no involvement in this project. If you take a look at the signatures, and we cite it in the record, it is record page 1311. There's about 5 signatures for Kevin Brody, and all of them are wildly different. Some of them were obviously forged, and you don't need to be a handwriting expert to see that. Also, so just based on the discrepancies in the signatures, and there's 5 of them that we show, it really appears that Mr. Brody was not involved in the project. Also, there were many, many emails in the record. Mr. Brody's name appears almost not at all, and he was in Pennsylvania. So I think, and also, supposedly Mr. Brody signed the lease and for the Wahlburgers restaurant, was an expert in running a hamburger business. He testified he had no experience in the hamburger business. So based on that, it appeared that Mr. Brody was not involved in the project. But more importantly, as the appellants point out, money was transferred out of the DuPont account, but the money was transferred back in November 2017. The project didn't fail because of eviction until June 2018. So even if Mr. Brody was somehow involved, that was not the cause of the failure of the Wahlburgers project. It was that Ms. Guo took over the project in late 2017. She injected herself into it. She didn't pay the back rent, even though there were sufficient funds to do it. And the landlord evicted the Wahlburgers because she was involved in the project and was not a suitable tenant. Any other questions? I see I still have some time.
I don't see any other questions. Thank you.
Okay, we'll
Unless
submit on
you-
our brief.
Yes, okay. Thank you
you.
very much.
My client, Ms. Guo, has been disparaged not only in the briefs, but also in the courtroom today. And not only is she suffering financial damages, but also reputational damages. On the issue of the money being back in, it was Mr. Pritchard who came onto the scene, who sort of tried to save the project, and he invested money into the DuPont account. So it was not Ms. Guo's money. She never stole anything. She never moved anything. She was trying to save help her clients and save the project. The project obviously failed. Whatever money was transferred into the account was returned back to the new investors, the Hong Kong company, and she or her firm never took a dime from the account.
Thank you very much.
Thank you.
Thank you both. Clark versus Con Edison.
Good afternoon, Your Honors, and may it please the court. Ross Frisha for plaintiff appellant in this matter. The motion court erred in granting summary judgment to defendant because defendant did not meet its prima facie burden because within its own papers, tribal issues of fact exist as to whether repairs, which fall under the ambit of the labor law, were being performed on the night in question. In any event, plaintiff...
Sir, that is the precise issue here, whether it's a repair to fall under the rubric of the labor law or a routine maintenance, correct?
Yes, and whether those repairs were being performed on the night of the incident. Yes, Your Honor. So...
And your client was charged with making electrical repairs. He wasn't replacing a light bulb.
Right, correct.
It was sophisticated wire work underground.
Yes, and that's what his testimony supports. If you look at the record at page 75, he specifically testified that he was to perform electrical repairs on wires in the manhole. He also testified that he wore a harness, a helmet, and a flame retardant shirt just in case of electrical malfunctions, and that's on the record at page 97.
But there is no argument on this record that he caused his own accident, is there?
I believe the defendant made that argument. That's a sole proximate cause argument, and my response to that, Your Honor, would be that he was acting pursuant to the directions of his supervisor, and this court has clearly held that a plaintiff cannot be the sole proximate cause of his or her injuries, where at the time of injury, he or she was acting pursuant to the directions of a supervisor. That's Harris versus City of New York.
What was the direction?
The direction was to open the manhole, and that was given before the appropriate barricade was set up.
So this was not an experienced person then? They had never opened a manhole before?
I'm not sure if they did or didn't, but I know that they hadn't, and the record is clear. If you look at the record at page 148 to 149, he testified that he opened the manhole at the direction of his supervisor. So he didn't know that he should get the barricade for the manhole before he opened the manhole. He was new at this. I'm not sure if he was, he probably had done this before, but at the same time, because the supervisor directed him to do so, that would negate the sole proximate cause, because the intervening cause would be the supervisor.
Oh, sorry, I just have to ask this one more.
Yes.
So he was told by his supervisor, open the manhole. And then he was told by the supervisor, get the barricade that has to go around the manhole?
No.
Is that what it was?
He was told by the supervisor to open the manhole before the barricade was set up, and the supervisor was at the job site.
So the supervisor told him, okay, time to open the manhole. He needed to tell him also that it was time to get the barricade? Didn't he figure out that he should get the barricade before he opened the manhole?
I mean,
Wasn't the supervisor just telling him, we need the manhole opened?
Yeah, well,
do your job and open it the way you know you have to by barricading it, etc. Why was he going to get the barricade if the supervisor didn't tell him to get the barricade?
Well, he was, to the extent that the record is not clear on that, that's a tribal issue of fact that needs to be put toward a jury. And I would say that if you look on the record at 148, 149, that's where that issue is delineated and addressed by the plaintiff. And to the extent defendant's witness, Charles Wissert, doesn't testify to anything on that front, because he testified on page 254 that Osmos would perform repairs on the Con Ed structures and that he was not knowledgeable as to the work that plaintiff was performing on the night in question. He also stated,
I don't know what any of that has to do with whether he was told to open the manhole and whether he had to give individual instructions about step one, get the material that has to surround the manhole before you open the manhole. Anyway, you have rebuttal time. Thank you.
thank you.
Good afternoon, Your Honors. Nicole Verzillo for the respondent. The lower court was correct in dismissing plaintiff's labor law claims as
On what basis?
plaintiff was not performing a labor law activity at the time of
Why
this
not?
accident.
This is a gravity related for sure. He fell through a hole and he was there to perform the repairs.
Plaintiff's
Electrical
testimony.
repairs, as my
Plaintiff's
colleague-
testimony.
excuse me, electrical repairs, as my colleague already spoke of.
Plaintiff's testimony that he was performing an electrical repair at the time of the accident is a feigned issue of fact if you look at the totality of the evidence in the record. Kurt
What
Sellis.
was Con Ed there for? He worked for a contractor who was doing Con Ed work, right?
That's
What
correct,
does
Your
Con Ed work?
The Con Ed, Osmos was performing work for Con Ed. They were supposed to make all inspections and necessary repairs in accordance with those of electrical repairs.
Okay, so that's what we're talking about.
That's correct, Your Honor, except that at the time of this accident, plaintiff and the crew were merely inspecting the manhole to then determine if a repair needed to be
do the
made.
work from the asphalt street. That's why he opened the manhole. They were going to go down. Not the way this gentleman ended up going down, but I think that's what they intended to do, go down so they could inspect it.
Yes, Your Honor, and that is considered a routine maintenance activity. They were performing
Which part of the electrical repair work was considered a what, did you say?
routine maintenance activity.
Routine maintenance.
The process of inspecting the manhole in order to then possibly perform a repair for an isolated event
So
is
that's
a routine
not
maintenance
the
activity.
feigned part, that they were inspecting for possibly doing it. The feigned part is that they were going to do it?
No, the
Or doing it, or what?
The feigned part, Your Honor, is
I mean,
that
don't you have to go and look at what you're going to do before you do it? I don't understand. Where did you expect them to do this examination from?
the fact that they went down into the manhole is still considered, or were going to go down into the manhole to perform an inspection, is still considered a routine maintenance activity.
So you're separating the work job, I mean, the contract that the employer had with Con Ed, I don't know the name, was to do electrical repairs of the system. Before they could actually start doing the electrical repairs, they had to look at it to see what electrical repairs they had to do. So you're saying during the time that they're checking to see what repairs, they're not part of repairs and it's a different kind of work? That doesn't make sense to me. Do you have a case that says that?
I do not, Your Honor, but I can say that at the time of the accident, the evidence was, there was an affidavit that was submitted by plaintiff's supervisor who was actually there on the day of the accident. He was an Osmos supervisor. His name is Kurt Sellis. That can be found at page 293 and 294 of the record. He submitted an affidavit in support of our motion for summary judgment to the lower court, and he unequivocally stated that the crew that plaintiff was a part of was a crew that was going to inspect the manhole. He never was stated that this crew was going to perform a repair on the manhole. They were inspecting it pursuant to routine maintenance of a manhole.
Other than that affidavit, is there anything else in the record that would say that this was maintenance as opposed to repair work?
I would say that the contract between Osmos and Con Edison that specifically states that the Osmos will perform all inspections and then make all repairs. I mean, I would argue that that is considered a routine maintenance activity.
So when they're down there and they inspect and they say, okay, we've got to take that out, we've got to replace that. Okay, that took 5 minutes. Now they're going to start repairing it. The first 5 minutes aren't included in that process?
At the time that this incident was taking place, they did not even know if a repair was going to be made. They were inspecting the manhole in pursuant to maintenance.
Were they going to close it up and go back to the office and come back another day to repair it?
That is unclear from the record, Your Honor.
But isn't there in the record, Mr. Charles Wissard, who's the senior specialist with the Environmental Health and Safety Construction for the defendant, that he testified that on the record 254 that the plaintiff and his coworkers were engaged in repair work? I mean, that's a lot different than routine maintenance, and they were involved in repairing network distribution equipment. I'm not talking about changing a light bulb here, which is the observation I made earlier. So as my colleague pointed out, you got to see what you need to be done, and unfortunately, the accident occurred as he was about to go down and check the distribution equipment and make the repairs as required by the contract. That is what's in the record by your own, I guess, witness or expert.
It was our witness, Your Honor, and I think that if you look at his testimony as a whole and not just that specific part of his testimony, I think overall his testimony is that they're pursuant to the contract, an inspection is performed, and then the repair would be made. Any electrical repairs that would be made would be considered electrical repairs.
Thank you.
Can I, Your Honor, just address one point about?
I'll give you 30 seconds.
Okay.
Because you've gone over the red light and the
I
time that
understand,
you
Your Honor.
requested.
I just wanted to address your point about plaintiff being the sole proximate cause of the accident here. You had asked the appellant if plaintiff was an experienced worker. He was not. Plaintiff was in training at the time of this accident. He was a crew member in training. He had only been on the job site for, I believe.
Well, then that goes to his point.
I don't think so, Your Honor, because I think
He
that
didn't know what he was doing, so the man shouldn't have given him step one, go take off the manhole. And then the supervisor is everything here if he was in training.
plaintiff had recently just completed extensive training, which
You
is,
just said he was in training
he was in
before.
training, but he had field training before that. He had a training at the Osmos facility prior to.
Either way, in your brief, I didn't see that you said anything about, you didn't bring this appeal on the basis of sole proximate cause.
I addressed plaintiff's argument about sole proximate cause in my responded brief, just to the point that the plaintiff was
I'm
provided.
looking at it and I see 2 points, not
It
that
is-
one. But anyway, thank you very much. We have your argument.
Your Honors, I just want to say that it's defendant's burden to show conclusively and as a matter of law the conversation that happened between his supervisor and him regarding sole proximate cause if they are to make that argument. And on a separate point, that an inspection and furtherance of a repair is covered under the labor law, and you can look to Mendoza v. High Point Associates for that site. That's a 83 AD 3rd one.
You're just asking us to reverse the granting of summary judgment to the defendant. You're not saying, oh, and we get it too. You're saying there's issues that have to be dealt with, but there shouldn't be a dismissal on the merits.
Yes, Your Honor, that's correct. And if there's
Thank you.
no further questions, thank you.
Thank you both. Global X Inc. versus Hogwarts Capital.
Good afternoon, Your Honors. May it please the court. My name is Tom Feeney, and I'm here today to represent the appellant's defendants. The common theme, Your Honors, on this appeal is that on the claims that were asserted against the individual defendants in the amended complaint, the lower court ignored well-established decades of law that this court has articulated, that when you want to, in a business transaction, which in the original complaint, this was a breach of contract action against the entity defendant. My colleague became new counsel after that complaint was filed. My colleague became new counsel for the plaintiff, and he filed an amended complaint as of right. And in that amended complaint, he asserted 4 claims
So,
against for the.
from what I just heard you say, are you conceding that the plaintiff sufficiently pled their claim for the breach of the oral agreement?
Well, Your Honor.
For the broker's fee.
The implied contract claim, if there's one claim that could survive, the implied contract claim against the entity defendant is the closest call, and the reason is because even on that claim, the only written agreement that
So
was.
it sounds like you're not arguing that point.
I do not concede that it was adequately pled, but if there is, but if Your Honor found that to be a close call, I could understand close calls. But the claims against the individual defendants, with all respect to the lower court judge, the lower court judge completely ignored, as if it didn't exist, without even a written opinion that he wrote. He read it out loud into a transcript, and it's very loose reasoning, and he does not address the decades of law that this court has articulated. For example, on tortious interference, I'm an officer of a company. For me to tortiously interfere with my own company's contract with a counterparty, this court has held that you need particularized allegations. It used the word particularized. This is not 1940s pleading. We are in the new era of complex, and where this court does not accept any claim, pass go, and get discovery. If you want to impose personal liability on a defendant, on an individual, you have to allege how did that individual act outside the scope of his authority or personally benefit. In this case, the 2 individuals, on behalf of the company, because they thought it was to the company's advantage, were alleged to have dragged their feet and not closed. That's a breach of contract. You don't get personal liability because when you act on behalf of a company, you drag your feet. That's a breach of contract. Now, fraud. Is there fraud?
There were no damages here. With fraud, you have to plead
Out-of-pocket damages. Here, the loss was the loss.
Give me a second, sir. Their claim is that they want their $800,000.
Yes.
So
you agree with me?
That was raised here, which is very important, is Section 13 of the PSA, Record 71, is the critical paragraph here because the broker was mentioned there.
Yes.
I know they're not third-party beneficiaries. We understand that. But it's clear that there is language to suggest that while you rely on closing being the basis for the earning the commission, there can be a basis based on the fact that there has to be a separate agreement, and the paragraph 13 doesn't say written, correct? It says agreement.
Your Honor, on the 2-minute reply, I will answer that question. Off the top of my head, I don't know if it's.
Well, I have it in front of me.
Context, in a commercial transaction.
And it just says a separate agreement between purchasers and each of the brokers. It doesn't say written agreement. So to follow up a little bit, there can be an implied contract for a commission based on broker services without the need for a closing as a pleading matter.
Well, that paragraph, though, still references that it's closing. There has to be a closing. So our argument, with respect, is that there would need to be a closing.
But that's if you're looking solely at the PSA. But all of the transactions that followed, all of the work they do suggests an implied contract there. They say that there was an agreement. And frankly, they started working in December 2019. There was no PSA until September 8th, 2020. This was a $70 million deal that they started working on and did a tremendous work. It's hard to believe they didn't have an implied contract that you're going to pay me an amount of money, $800 or whatever they said, in the 9 months that they were working before any PSA.
But Your Honors, there is clear case law that if a broker wants that fee without a closing, you can say that in the contract. In this written contract.
Yes, but this is a motion to dismiss. On the facts here, that was my first question. I was trying to give you an opportunity to get to your other stuff.
Yes.
But That's all I was asking.
I understand,
was
Your
whether or
Honor.
not.
I understand, Your Honor. I would, again, I do agree with you that if there's one claim that would survive, it would be the implied contract claim. I have the argument you may not agree with, that since the only writing refers to a closing, that he hasn't alleged enough that you would get a fee without that. But the most important thing for me today is to answer any of your questions about the individuals, because this court, the lower court, just got it wrong. It's not right that individuals can just be lassoed in with loose pleading like this. It's not fair.
Thank you.
Good afternoon, Your Honor. Your Honors, may it please the court. The decision of the
Why
court.
don't we pick up where counsel just left off? I think you should get to that point.
Yes, Your Honor, absolutely. And specifically, the question is, why should the claims against the individual defendants proceed, right?
That's right.
Understood. Well, I think it's easier to take it claim by claim. So with respect to the fraud claims against the individual defendants, I think that the most important item for the court to look at here is the pleading standard as amplified by 3016B. 3016B is often used to insinuate or to require a plaintiff to plead very specific facts about a fraud, to essentially be omniscient, to see everything, and then to put that in the pleading, in the complaint, which is, of course, the initiatory pleading in a lawsuit. This is, of course, not possible, and I want to direct your attention to the case Pleading versus Northern Leasing Systems. That's 10 NY 3D 486, Court of Appeals 2008.
Have you stated all the claims for fraud here?
Yes, Your Honor. I believe that we have. We have stated claims that there was a material misrepresentation of fact. And
What was that?
I'm sorry, Your Honor?
What was the material misrepresentation of fact?
The material misrepresentation of fact was made over the course of the beginning of the relationship between my client and the sellers, and the buyers, the individual defendants, and the defendant entity Hogwarts, where they said, we have the money. We have the money. This is a $70 million transaction, as the court noted, and this is where it's at. It's in United States dollars.
You mean the proof of funds letter?
The proof of funds letter, yes, but it's not
They
just.
didn't sign. I don't think their names are on that proof of funds letter.
That's correct, exactly right.
And it says buyer beware or something, not exactly that. But
Exactly.
watch out. I mean, what is the language exactly that tells everybody,
Exactly, and yes, Your Honor, and as we all know.
own risk?
Indeed,
Your own
and
risk.
that's correct. That's correct. But at the same time, no one is going to start working, least of all my client, if there's not a proof that there is money there to pay for the hotel, number one. And that's just the very beginning, right? If you
So
look at
your clients, even though it said own risk and whatever else it said on it, still believe there was truth to it, that this money existed.
because my client was told by the defendants, including the individual defendants, that yes, we have the money, it's here, it's earmarked for this specific transaction, and this is just the beginning, right? As we go along in the transaction and as we continue to draft the PSA, obviously we're going to give you more information.
So even if there was some misrepresentation in that proof of funds letter, how did that actually cause this deal not to close?
Well, Your Honor, I think that your question is it's been set up by the defendants as this is the only way for us to be able to survive a motion to dismiss on the fraud claim by connecting the misrepresentation to the failure of the transaction to close. That's a misreading by the defendants of the complaint. The complaint, in fact, asserts something very different, which is by virtue of the fact that the defendants had misrepresented that they had the money and that it was earmarked for this transaction and that we were going to go forward, my client worked for months and months and months and months to his detriment, put out money, expenses, cabs, and again, this is in spring, summer of 2020. We all know what that was like.
Yes.
Indeed, right? And also paid for things, right? So we're not saying that by virtue of the fact that the proof of funds statement, which indicated that they had the money and that it was earmarked for this transaction, turned out to be wrong, and therefore the hotel was not purchased. We're not saying that. We're saying that my client relied on the representation that the money was there, and that the subsequent representations by the individual defendants as well, that they were going to provide more information and more financial data.
Well, the thing is, on a fraud claim, and I think you would maybe we had discussed this earlier with defendants' counsel. Is there any out-of-pocket damages from the fraud, or it seems like what you're seeking for everything is the $800,000 brokerage fee for the work that you did, and there's no dispute that you did work over a long period of time.
Your Honor.
So that implied contract seems like a really strong, at least at the moment, possible cause of action, but some of these other causes of action, are they as strong?
Your Honor, I understand different causes of action have different levels of strength, but the question before the court here is whether or not they are sufficiently pled to survive a motion to dismiss based on the arguments below and the arguments presented here today. With respect to the fraud claim and your question as to whether or not there was any damages, yes, exactly right. So we have, I can point the court to paragraphs where we discuss precisely what it is that my client had paid for in the execution of his services as a coordinating broker for both parties, right? And the amount of time and energy and actual monies paid out. We allege that in the complaint. I can get you the particular paragraph. We don't specify the exact dollar amount because we do not have it yet, and obviously this is pre-discovery, but the complaint does allege that he expended funds, expended time, had to hire people to perform all of these duties for almost 9 months before the PSA was even signed, and of course, additional work thereafter. Our contention is that that is more than satisfactory to survive dismissal at the motion to dismiss stage for the fraud claim.
Thank you.
There are no further questions. We ask that this court affirm. Thank you.
Thank you, Your Honors. Most strikingly, there is no allegation in the complaint that there were no funds. If there were funds, they were in Hong Kong and by an affiliate. The proof of funds statement said an affiliate has funds in Hong Kong. The complaint never alleges that that was false. There is sleight of hand here because later on in briefs, my friend argues, well, we thought it was in the US, but the complaint doesn't allege that. The complaint never alleges that we said it was in the US to the plaintiff. There was no false representation about the existence of those funds. Number two, reliance. They didn't like that it was being made by an affiliate. And in the complaint alleges that they asked Hogwarts for more, and Hogwarts said, no, deal with it. You don't like it, this is what we have. We have it in Hong Kong. And they went forward and did all that work knowing that that money was not in the United States and that it wasn't even owned by Hogwarts. Under this department's sophisticated commercial line of authority, you don't get a loosey-goosey fraud claim like that. That doesn't meet you didn't plead reliance, and you didn't plead loss causation, and you didn't avoid the out-of-pocket damage rule. There are 4 independent reasons why the fraud claim should have been dismissed, and the lower court judge completely ignored it. And then on the tortious interference, the lower court judge, this is at page 164 of the record, I, in my reply brief, pointed out that the Devash case of this court does not talk about bad faith. You can't just allege bad faith to have a tortious interference claim against an officer. And despite my having pointed that out, I pointed out that the bad faith line in the Devash had to do with specific performance. It had nothing to do with tortious interference. And the lower court judge on page 13 of the verbal transcript created says, there's a question about whether they acted in bad faith, but that's not the law. The question is, did you make a particularized allegation in your complaint that the individual defendant acted outside the scope of the authority or got a personal benefit, like bought a house with the money? There's no allegation about that here. There's only an allegation that they wanted to save the deposit for Hogwarts, so they slowed down the deal. And unless there are any other questions, my greatest concern here, Your Honor, is that the individual defendants really should be out of this case.
Thank you.
Thank you, Your
Thank you
Honors.
both.
Thank you.
People versus Joyce.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Mr. Joyce. The motion to suppress should have been granted for 3 reasons. First, by keeping Mr. Joyce in handcuffs even after the police confirmed that he was unarmed, the police effectuated an arrest without probable cause. Second, the vague and imprecise description that the police had did not justify a seizure in the first instance. And third, the show-up identification procedure was unduly suggestive. Turning to the first reason, handcuffing is the hallmark of an arrest, and if it is applied without an actual safety or flight concern.
Well, didn't the officer say that he did it because this person was just 2 blocks away, had been fleeing, he was caught in the act of fleeing, and he knew that he had used a weapon, or the person who he was chasing, whatever, had used a weapon, a gun. So he was concerned for his safety to that extent. Wasn't it fair for him to put him in handcuffs until to ensure his own safety at that point?
2 things, Your Honor. One is the record actually shows that Mr. Joyce was only seen walking in the neighborhood at the time that this
Walking
happened.
with that description, yes.
In the mid-afternoon. It was, during the day.
Well, that's when the 6 shots were fired into the apartment, so that's when it was.
Right.
Very shortly afterwards.
Yes, but they also they did a pat down and confirmed that Mr. Joyce did not have any weapons. And there's case law that says that the nature of the incident itself does not alone justify the.
But it wasn't the nature of the incident alone. It was the nature of the incident alone, was the fact that he was, at least on the radio one, running. When he saw him, he was walking, that he met a description, man with a black hoodie who was carrying a jean jacket, and that he was in close proximity and within a close temporal aspect. So all of those things gave the officer reason to believe that this was the person who was a violent person. One would assume that about someone who had just shot a weapon. So wouldn't that have been enough?
No, Your Honor. And just to clarify again, the radio run reporting someone running, that was actually in reference to the other.
Well, the first person was running, but
Right.
Okay, so the second person was never running.
There's no evidence. There was
Okay.
no testimony adduced at the hearing, and in fact, I think at one point.
Okay, let's ignore running and keep all the other facts in.
Sure. So under these circumstances where, again, Mr. Joyce was only seen walking, he was patted down, he had no weapons, he did not act in any evasive way, no threatening way, he complied with the officer's demands. Again, the law states that in the application of handcuffs, if it's unnecessary, elevates an encounter into an arrest, and this court has repeatedly held in cases where there was no evidence, again, adduced at the suppression hearing, that the defendant acted in an evasive way or threatening way, or a pat
This
down.
was one officer. At the time, it was one officer against one individual who was alleged to have just shot Mikey with 6 gunshots through a closed apartment door. And this officer sees him, pats him down, and there's nobody else around when he does that. You're saying it's unreasonable for him to put him in cuffs? Have we never seen a situation where an unarmed defendant overtakes a one-to-one police officer, removes the gun, and the officer's dead?
There were actually 3 other uniformed officers along with
Not when he first stopped him.
There were, Your Honor. So Officer Carter was driving along with his partner, and when he saw Mr. Joyce walking, he signaled to another police car that included 2 police officers to assist with the stopping of Mr. Joyce. So when Mr. Joyce was stopped, there were 4 officers at the scene, actually, when they grabbed him, pushed him against the car, and held him, and after patting him down, they still applied handcuffs, which I argued was unnecessary and converts the encounter into an arrest. And in addition, at the outset, the very vague description that the police had provides a second and independent reason for suppression here. All that the police had in this case
But was it really vague when you consider the time and the distance? I mean, this is not puffy bubble black jacket, radioed 20 minutes after, that people stopped 20 minutes after the radio call far away. This is 2 blocks within a very short time. And he's wearing something, okay, he had the black hoodie sweatshirt, but he has a jean jacket with something on the back of it, some art or some description on the back of it. And he's found holding the jean jacket.
So, Your Honor, in terms of the design, there was no description, again, adduced at the suppression hearing of what that design was, so we have no idea. And Officer
We have a
Picardo,
jean jacket.
yes, and I submit that that piece of clothing is still a common type of piece of clothing, like a black hoodie.
Not like a black bubble jacket, not like a black hoodie.
Perhaps less common, but I think still sufficiently common that it doesn't provide enough details in order
But it's
for-
not the only thing.
Well, I think, Your Honor, I think this court has recognized, for example, in an opinion that Your Honor, Justice Renwick wrote in People versus Bilal, that
That was the black bubble jacket, and those facts were not like this.
they're not
one.
exactly the same.
No, there were tons of people. It was melee. It was 20 minutes late they got this guy. He was not nearby. This was nothing like it.
I'm just submitting that the general proposition that a vague description is not enough to justify reasonable suspicion.
Right, there was more than just a vague description there, but there was definitely, when you go out on the street, you could see tons of people with black bubble coats. This was not this.
Right, I would respectfully suggest otherwise. Thank you.
Good afternoon, and may it please the court, Catherine Radna for the people. As initial matter, defendant's suppression claim is foreclosed by his valid waiver of appeal.
Well, it's not a valid waiver, is it?
I would argue that it is a valid waiver.
So all that's necessary is that a judge throws out some words, and the defendant's supposed to catch it and figure out what the context is he's talking about?
Are you referring to the retaining certain appellate rights? I mean, the oral
They're not
colloquy.
even sentences.
I'm sorry.
They're not even sentences. The words are not even, they're not even given in sentences.
Counsel, are you saying that giving up your generalized rights to appeal is sufficient to inform the defendant of the separate rights?
Yes, Your Honor. Well, first, the court separated his trial rights from his appellate rights. He listed the rights that he was automatically forfeiting. Defendant confirmed that he understood. Then he moved on to saying that additionally, and as part of this plea agreement, he was giving up his generalized right to appeal. Then he further stated that he would retain certain appellate rights.
However, you do retain certain appellate rights. For example, any sentence I oppose upon you would be an illegal sentence, or you were denied constitutional speedy trial rights in this case, or you do not have the legal capacity to stand trial and to execute this plea agreement. You may challenge that on appeal. What is that? That's practically, it's not even English sentences, and a defendant's supposed to know what that is?
And I just want to add that the defendant didn't respond initially. Can you repeat that, please?
And then it came out that he didn't even indicate one of the points in it initially.
And the judge didn't ask the attorney, did you go over the written waiver? Did he read it? Did he sign it? Did he?
The defendant did sign it, and his counsel said that he executed
Did the
open court.
judge ask
The
about
judge
the
never elicited on the court understanding.
I think you should move on to a more.
Okay, if you reach in the
another
interest of
point.
justice, the officers had reasonable suspicion to detain defendant, and then had probable cause once.
What about the stop that counsel says wasn't a one-on-one stop? How many officers initially stopped him?
So
Why
officer.
the cuffs? Why the cuffs if there are armed officers, multiple?
The use of cuffs does not render detention into an arrest.
Depends
And
on
here,
the circumstances.
well, minutes earlier there were shots fired, so there was an active shooting situation. The defendant, there was an.
They patted him down.
They patted him down to see, for their own safety, to see if he had a gun. There
What's the pat? The pat down is to find out if he has a weapon, right?
Correct.
So they did that.
They did that, and then
They put cuffs
he remained handcuffed 3 minutes for temporary detention so they could have a prompt on the scene identification of defendant.
Wasn't he still cuffed later when there was a show up?
He was cuffed during the show up procedure, but
So
again,
then he was recuffed, uncuffed, recuffed, or
he remained cuffed during those 3 to 5 minutes. But handcuffing does not render detention into an arrest. The show up procedure was not unduly suggestive. Show ups are inherently somewhat suggestive. Here, it was not unduly so.
What did it need to have additionally to be unduly suggestive here?
Well, so here it was 3 to 5 minutes after the original detention. He was only 1 block away from the scene of the crime. In the Cruz case that defendant cites, the show-up procedure was an hour after the crime happened.
It's not that. It's not that. There are other circumstances here. What do you have to say about the other circumstances?
About the...
He's flanked by 4 uniformed police officers.
He's flanked by 4 officers. Their guns are not drawn.
The guns have to be drawn in addition, pointing at the defendant, who they're standing on either side of, one holding on to him. Now, the difference is we have to have the guns drawn to make this?
In these circumstances have been upheld as not unduly suggestive. In Cruz, which this court has held as unduly suggestive, there was lights being shown in the shown brightly.
Yes, I know. I was on that case, I believe. That's not this case. It was a different case. I think we already talked about the time, space. There was a headlight shining on them. That's not this, but they're flanked by the officers and the red lights are going and someone in the car says, over there, directs over there.
That's correct, but that's also just the inherent nature of a show-up identification. They're always a little inherently...
Counsel, so it's not suggestive that he's in handcuffs, surrounded by police officers. One is touching him, and there's police cars around him. That's not suggestive?
I think it's a little... they're always a little bit suggestive, but here are not unduly so.
Okay, thank you very much.
Thank you.
Your Honors, I'll just quickly address the show-up point since it came up. The procedure here was unduly suggestive. Mr. Joyce was, as Your Honors have recognized, was handcuffed, surrounded by 4 uniformed officers, and even though he had already been handcuffed, they did still physically restrain him. The lights from the police...
Well, I think his hand was on him, just wasn't grabbing him like this. He had a hand on him.
Right, there was physical contact.
There was physical contact by them standing next to him. But this was very quickly after they had already grabbed him. This was like that.
Yes, but...
Very, very quickly. Seconds, not seconds, but minutes. It was very close to the time he was stopped.
Aside from, even if a show-up was done close in space and time to an incident, it still must not be unduly suggestive. And here, the totality of the circumstances render it so. I would point out that the respondent's brief fails to account for all the totality of the factors here. They also fail to cite a single case that has upheld the show-up procedure that deployed all the suggestive factors used in this case. And for this independent reason as well, the show-up should have been suppressed. Thank you, Your Honors.
Thank you. Thank you both. Stevenson versus New York City Transit Authority.
Good afternoon, Your Honors.
Oh, I'm sorry.
I'm sorry.
Counsel's not there yet. Okay.
Good afternoon, Your Honors. Kenneth Gorman for the plaintiff appellant. This is a simple rear-end collision. The plaintiff testified that the bus operated by Claudia Alvarez rear-ended the right side of her vehicle. Based on these facts, the Supreme Court stated that the plaintiff met her prima facie burden and noted that Alvarez did not submit an affidavit in opposition. Denying plaintiff's motion based on Alvarez's unsworn statements in the uncertified accident report and MV 104 cannot be reconciled with the case law from this court.
Is that, I'm sorry, is that what was raised by you on reply?
Reply? In reply, you said we talked about it being inadmissible. I don't know how specific we were in a reply, but the defendant... Yes.
You could not have addressed it earlier until they put in opposition to your motion for summary judgment based on a rear-end collision as a matter of law being a prima facie case of
Correct.
negligence, correct?
Correct.
Because your client basically said, I was stopped even when the light was green because the cars were in front of me, I was stopped.
Correct.
Fair?
Fair.
So until you saw the opposition papers that contained those transit documents, even if they were made in the ordinary course of business, and even if they were business records, and nonetheless, there was hearsay there, correct?
Excuse me?
There was hearsay.
There was hearsay there.
By
That
the
was correct.
driver.
Self-serving
And
hearsay
there's no
statements.
affidavit by the driver.
No affidavit.
So then
No
how could that
affidavit.
trump this?
It
That's your
can't.
position.
Excuse me? It can't
That's your
trump.
position. So by raising this issue in reply, that's not a new matter.
It's not a new matter. It absolutely is not a new matter.
What about the evidence of a side swipe here?
Evidence of the side swipe.
The other, the New York
Well,
City Transit
there
says
is no
it was a
admissible
side
evidence.
swipe.
There is no admissible evidence of a side swipe. I mean, admissible evidence. We have self-serving statements from Alvarez and an uncertified accident report written by her supervisor. But with that being aside, even though those versions are different, it's uncontested that the plaintiff's vehicle was rear-ended and that Alvarez did not come forward with a non-negligent explanation.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Teresa Frame from the MTA Law Department on behalf of defendants' respondents. I'll go right past my opening and address Justice Schulman's point with admissibility. First, let me just say that admissibility was not raised in any specific manner whatsoever. You can't just say, you know, everything's inadmissible. You have to have a specific basis or at least cite some sort of law. Otherwise, you're just throwing the kitchen sink at it, and then you're waiting for the appellate court to sift through it. My friend also does not address that there's two levels of hearsay that he's trying to argue. The first level is business records, which I believe under this court's decision in Nasser and your following decision in Rooney versus George Hardy's St. Francis Apartments, that those the MTA's records qualify as business records according to their counsel's affirmation brought that in.
Yeah, well, I don't think that's an issue, really. I mean, let's accept that they're business records made in the ordinary course when this accident occurred, as opposed to being prepared for litigation.
Sure.
Nonetheless, we know that well-settled case law, that business records like this or business records like police accident reports that contain hearsay information that the officer would take from the respective drivers in a particular accident would all be hearsay and inadmissible and would probably have to be redacted unless it's an admission. We don't have an admission here, do we?
Well, Your Honor, we do have the admission from plaintiff saying that she was not stopping at the time of the accident. She says in one of the reports that she had not begun her stop. The light was turning yellow, the MTA supervisor notes, but she had not begun her stop. So we do have that. Plaintiff does not discuss where the impact really occurred to the vehicles.
The pictures show it was in the back, and she says it was in the back.
The
Says
pictures
it's
show that
rear
it's really more towards the side. It's the
back.
It's on the quarter panel of the plaintiff's vehicle.
Isn't it really the back light of her car that was in the back? I didn't think it was really
The right rear light.
panel.
It's certainly is the rear light, which is on the quarter panel. Yes, I'm not debating that. But what we have here is we don't have any definitive or really clear evidence as to where the bus was in regard to the plaintiff's vehicle. She doesn't say, I saw the bus behind me, then I felt the impact.
I've been wondering why on a motion that plaintiffs makes for summary judgment on this issue, did you not put in an affidavit from the bus driver?
Certainly, Your Honor, that would make this issue easier and
Yes, it
perhaps
would.
my job easier. However, I believe with these business records combined in the first level of hearsay and then the second level of hearsay, plaintiff's admission against interest, as well as the fact that our own bus operator's statement within that business record is not bolstering because we have not submitted any other evidence that we've shown that this was an accident where it wasn't perhaps. We've shown that there's a dispute as to how this accident happened. The bus operator in MTA's reports say that the plaintiff's vehicle was on the left, moving next to the bus, and moved from right to left, and that's how this.
Well, it had to have been in front of the bus to move from the right to the left. In any event, the bus was behind it, given where the bus hit it.
Certainly, the the plaintiff's vehicle was in front of it, but it's not clear whether it was in the same lane or not, because if you see, the impact is on the bus's rear side mirror, which is quite far distance from the actual bus itself. It's not like, you know, the bumper of the bus.
But it's
is
still
what's
hit
colliding.
the back rear light.
It's certainly the rear light. It's more positioned on the quarter panel, Your Honor, yes. And let me just, since my time is up. Thank you very much.
Thank you.
Just briefly, rear end, right on the record. The pictures in the record clearly show that there's a rear end, right in the back. You can't get clearer that this was a rear end collision. I mean, no matter how you look at it, even if the party's testimony might be different. I mean, this court held in Morales versus Consolidated Bus Transit Authority, that sworn testimony, although differing as to the movements of the bus immediately prior to the incident, were consistent to the extent that they established, without contradiction, that the car was rear-ended. This car was rear-ended, and Claudia Alvarez's failure to submit an affidavit warrants reversal. Thank you.
Thank you. Thank you both. Rothman versus Radna. Yes.
Good afternoon, Your Honors. May it please the Court, my name is Lisa Shrewsbury. I represent the defendants' appellants in this matter, Sandra Radna and her law firm. She represented the plaintiff in a matrimonial action. She was retained in October of 2019, I'm sorry, and the trial was supposed to start really within weeks of that. She managed to get the matter moved to referee Marie McCormick, and the idea at that time was to settle it. She worked very hard, spent a lot of time on this. At the time the plaintiff came to my client, she'd already spent $400,000 in legal fees, which is a lot. So my client was the fourth attorney on the matter. She worked with the husband's attorney before referee McCormick. They weren't able to really resolve it. Although they came close many times, it just didn't work. So
there was a hearing on a charging lien, and at some point, the plaintiff asked to dismiss it, and instead they entered into a stipulation that was with prejudice.
That's correct.
Is that right?
Right, and it's actually more involved than that. So she filed her charging lien a few days after Mr. Petrush was retained to step in and replace her. He filed a motion to vacate the charging lien. There was a lot of motion practice. Judge Conway issued his order. They moved to re-argue it. It was a tremendous amount of paper. We finally got in front of Judge Conway on May 18th of last year. We had a full day of hearing.
And it was in the midst of the hearing that the other side wanted to withdraw the motion to vacate the charging lien. Is that correct?
So we got through May 18th. Mr. Petrush finished his direct examination of Ms. Radna. Done. We left. We came back for the next day, which was May 22nd, and they tried to withdraw the motion. Judge Conway said no. They raised a couple of different arguments, including that Judge Conway was acting outside the scope of, that he was, I guess, yelling. I mean, there was a lot of...
The question here is whether they are collaterally estopped.
Yes,
by
that's
the
correct.
stipulation that was without prejudice that took away this whole issue about payment.
Right, right. So the stipulation was entered, it was with prejudice. There was a lot...
They actually directed the withdrawal, in other words, the plaintiff actually directed withdrawal of funds to satisfy the lien.
That day.
Right.
That day. I mean, we fought it because we knew it was going to have a collateral estoppel issue in the New York County action. So everybody was aware of what was going on. I walked out of that courtroom that day satisfied that we would have
You
a
were
collateral
finished.
estoppel argument. I called up the plaintiff's attorney, who is not this gentleman, but the other attorney, and I said, okay, I guess you're going to withdraw now. And he said, are you kidding me? No, we're going to go forward. So we made the motion, and I was actually very surprised by Judge Kotler's decision, and her denial on the collateral estoppel issue was that the issues didn't overlap. And I think that there's a total overlap. If any one of you has any questions about that, please let me know. I hope I briefed that adequately in the record. It's just crystal clear. And in the plaintiff's opposition brief, they actually admit on page 31 to 32 of the opposition brief that they call it a withdrawal. They say that they withdrew the motion and it has no effect, but they say if they had done it with prejudice, then it would have a collateral estoppel effect. So there's an admission really by the plaintiff. They dispute the procedure of what happened on May 22nd, but they don't dispute the fact that the issues all overlap.
Well, it's tough to dispute a stipulation signed by both parties and so ordered by the judge that says withdrawn with prejudice and provides for the withdrawal from the IOLA accounts of the fee that this case and that case were,
They're
correct?
Right on all fours with each other. The court actually, asked a lot of questions. We were there all day. The court asked a lot of questions, and on the record, and it's in my brief, Mr. Petrus said, you win, we lose, this part of the case is over. I have that in my reply brief. I've cited to the part of the transcript in the record. There was no question in my mind or my client's mind that settled the issue. Thank you.
Thank you.
My name is Alex Petrush. I've been already spoken about. I'm not only the matrimonial attorney in the case still going on. And by the way, thank you for hearing this appeal so quickly. If we were in the second department, it would be 2 years, and the bench would not be nearly as hot as this. I've so enjoyed being here today. Now for my work. I was there on May 18th. I was yelled at, berated, called a second-year law student, although I've tried over 100 cases and 150 appeals.
Well, I'm sorry about that. We won't do that, but we do want to get right to the issue.
Thank you. I've seen the way you behave. I know you won't. There was no way we could get a successful vacatur of the lien. So I told Judge Conway we withdraw with prejudice. He would deny the application. That has only to do with that lien. In order to have collateral estoppel, I was aware I could not have a finding of fact made by the judge against my client. There is no finding of fact. You need a finding of fact so that we can't raise that issue again. That's exactly what Justice Cutler said. That's what we argued before her, and that's what we argue now. It is a strict requirement that there be a finding of fact. We withdrew it. The only thing that was done was we gave the $141,000 back because there was no way we would have a fair trial. In fact, Ms. Shrewsbury referenced the yelling, the complete, I hate to say it, I was in front of the man this morning, the complete absence of judicial moderation and appropriate conduct.
But how do we remedy this idea that it was with prejudice? It's with prejudice.
Yes,
So the
easily
claim,
I'm sorry.
Yeah.
I was enthusiastic.
yes, I want to hear.
We can't make another motion for lien. The motion was for a lien. It wasn't for anything else. We wanted to vacate the lien because we saw we could not win the hearing.
The thing is, it had to do with the legal fee. I mean, that's what you were talking about.
That's all.
And so if you said, okay, I'm giving you permission to take the legal fee, how can you now bring a case for malpractice that suggests that they weren't entitled to the legal fee because there was malpractice? You already gave them their legal fee.
No, I permitted the release of the legal fees because I knew there would be no findings of fact if I withdrew the application.
But what else was the legal fee for but the
The
work
legal
that had been
fees at
done?
that point does not take into account the enormous malpractice that we describe in detail in the brief.
But why couldn't you bring that up? Wasn't that something that you were also considering at the time that you made the motion to vacate the lien, that there wasn't a financial expert, et cetera? And you had the opportunity to have the hearing then.
All we wanted was the $141,000 that was being held in escrow or being held. So we did not want the appellant to get the money, so we moved to vacate the lien. We have a hearing. The judge is outrageous in the way he's treating me. And I said to my client, who's here, we're not going to win this. This will not be collateral estoppel because we are not acknowledging anything except that she can take her money. We withdrew with prejudice because that meant we could not make another motion for the lien. Not that we were going to vacate the malpractice claims. We intend to preserve that in our action. And we have done that. Justice Kotler held, and you have read my brief, judging by the way this bench is so hot, the enormous malpractice is hard to describe. How you take $1,700,000 asset and without the knowledge of my client waived it. You take forensic reports which would show that the husband was.
With regard to the forensic reports, didn't the judge say there's nothing, she challenged nothing in those reports? She just said, yep, you had to have your shoulder replaced, you were beaten, all of this. She gave it, you had tremendous emotional harm, she gave it all.
This is what the judge said. You're talking about the post motion. When you looked at the original decision, you say, how can it be that there could be a marital asset? And I knew the account worth $1,700,000 and not be in evidence. How can there be 5 years of maintenance in a 25-year marriage? How can there be $11,000 a month, which may sound like a lot, but nothing compared to the enormous lifestyle? I then made a motion for 4404B, and I had it served on the appellant so that she could answer it. I claimed there was a secret agreement. And I later learned in the decision that there had been an agreement to which my client was not a party, which is not denied in the brief, in which her rights to forensic reports, which showed the husband was making $600,000 a year, not the $24,000 that we knew or he alleged, and that the business, which was waived, is worth at least $1.7 million. So you have $3 million of damages to start with. I have a strong malpractice case, and so does Justice Cutler. Just because I told Justice Conway, who denied my motion to withdraw, that's how prejudiced he was. Yes, Lisa, excuse me, Ms. Shrewsbury, there was a lot of yelling. It was all described, it was all directed at me. I do not know why, but I've been around a long time, 54 years at the bar. I have never been treated like that in a courtroom. I'm a second-year lawyer.
About that again.
But
Thank you very
understand that with prejudice had to do with that money and that money only. Thank you.
Thank you. Just a couple things. I was there too, and there wasn't a lot of yelling. You'll see from the transcript that the judge was just as hard on me as he was on everybody else in the room, and it was another day in court.
So that I'm clear in my mind, in seeking to vacate the lien, counsel for the plaintiff asserted legal malpractice. In a sense, he was saying you have no right to have a charging lien because I discharge you and you're not entitled to the money because of legal malpractice, correct?
Well,
Isn't that the underlying basis to vacate the charging lien?
Well, they moved to vacate the charging lien because they said you're not entitled to
But
get
not in
paid
a
because you
vacuum.
committed malpractice, and we said
Because of legal malpractice.
we showed up that day.
Bear with me for a moment. That is the underlying issue.
Yes.
That's what collateral estoppel is all about. That's why I'm trying to make sense of it.
Right.
So if the underlying motion wasn't just about vacating the charging lien, it addressed the issue of legal malpractice
Entirely.
as a basis to vacate the charging lien, correct?
Entirely.
So now when you withdraw the motion with prejudice, you're basically withdrawing the very issue that you're now reasserting.
That's correct. And there's plenty of case law that says that setting a lawyer's fee in other circumstances where legal malpractice isn't raised during the dispute over the fee. Did you spend too many hours? Did you bill too high of a rate? If there's an account stated or an agreement on the fee that's, judicially so ordered, that also precludes a legal malpractice claim, even though the malpractice wasn't at issue in the fee dispute.
Stated differently, by agreeing to satisfy the legal fee issue, but satisfy the lien, pay the fee, that sort of moots the legal malpractice, right?
I totally agree. Right.
Thank you.
And I
I'm
should stop
sorry.
right there, but I do have.
Thank you very.
Oh, am I done?
Did you have something else?
Well, there's a couple of.
You have 4 seconds.
Okay. He just misdescribed the reason that Judge Cotler did
I think we
not
understand
say
the argument.
that,
Then the red light is on. Thank you very much.
Thank you.